We're on section 9, which deals with contracts for personal services and enforcement. And there's a whole bunch of issues that this section opens the door for us to start to think about. But we also have scheduled the Rules of Civil Procedures 26 and 27, which talk about the scope of discovery in civil cases. And the federal rule has been modified a little bit in recent years. It used to be thought that the ability to gather information from the other side was very liberal and generous. But over the last few years, especially in federal court, that right has been limited and the rule has been changed. The new watchword with respect to discovery, and obviously you are not required to turn over privilege information, but beyond that, what the sides are able to obtain from each other once the voluntary disclosures have been made pursuant to Rule 26, historically would be anything that's relevant or that which might lead to relevant evidence, which is pretty broad in scope. But the new rule really talks about that discovery should be, and the watchword is proportional to factors in the case that one looks at. And those factors can be the size of the case. So in essence, in a smaller case, then the court may not allow you, and it has the ability now under the change in the rule, to not give you the same breadth of discovery as one would in a case that's more significant. And that should be worrisome because the court then has some ability to determine what how meaningful the case is to either the plaintiff or the defendant when it may be for a relatively modest amount or seeking modest relief, but nonetheless likely every case that a plaintiff brings or that is brought against someone is pretty significant. But the new rule talks about proportionate to the value of the case, proportionate to the financial circumstances of each party. And so the court now has a greater ability to limit the discovery, and especially with respect to e-discovery, more often than not now, the court tends to look at what we call staged discovery, which means there'd be phases, so that we see to what extent that the discovery supports the person who's seeking its version of the events, and to the extent it does, maybe you'll get some more, and to the extent it doesn't, you may be limited quite early on what you can obtain from the other side. It's no longer a fishing expedition where I'm entitled to obtain all sorts of information from the other side. It's now the court, at least in the federal court, and this might make a difference then as to where you decide to file your case. Because the new change in the federal rule has given the court a much greater ability to limit the scope, the length, the entitlement to obtaining information from the other side, regardless of what form it may be in. And so it certainly makes me a little more leery about running off to federal court, knowing that I might have greater difficulty in obtaining what would normally have been clearly information I would be entitled to from the other side. So it might be another factor you start to think about as to where you're going to enter that suit. And all things being equal, maybe you're better off in state court, which has not changed the rules with respect to that scope of discovery, and they don't use the term proportional, so that you have a little better access to that information that historically we have been allowed access to. But this week's cases deal with personal services contracts, and they're interesting issues in remedies, because a lot of times in personal service contracts, the question is can I get orders from the court, orders to enforce those covenant not to compete provisions, and we've looked at that, but the provisions within personal service contracts, and to what extent will the court issue injunctive relief with respect to those types of contracts, because they're unique. It's not for the tape recorder that you want returned to you, or the automobile, or a ship, or anything like that. What we're now saying is that these contracts deal with personal services that individuals were to perform. And so the court has to be leery from a couple different standpoints of what it does with those cases vis-a-vis injunctive relief. Because not only is there a question about then involuntary servitude, but there's also the long-standing question of, well, how do we even police compliance with an order that would force someone to do certain things? How do we know then that if we order them to do it, that it's been done appropriately and all? So it becomes a big question as you start to figure out how that court of equity, or historically a court acting in an equitable capacity, can order certain relief, and then how are we going to gauge whether that order has been appropriately carried out. But the first case we have in the sequence of these on personal service contracts is American Broadcasting Companies versus Wolf. Wolf was a sports writer, a sports caster, personality for WABC TV in New York. The way a lot of these media contracts work, they spend a lot of time and money developing the personality, and people become attached to them, and they don't necessarily want you going to work for someone else with all that goodwill generated and paid for by my money. So Wolf had negotiated the provisions with the contract, his existing contract, but decided he could make a lot more money. And so what he did, with your help, is circumvent the terms of that contract. So I get, and hopefully you read the case, because I think it's a really interesting case. And so now what we've got is CBS and ABC, and obviously the sportscaster himself, trying to decide what the court can do about this, because ABC doesn't want him breaching this contract, or as they see it, breaching the contract. Let me ask you that first, I guess. Did he breach the contract?
Yes.
I heard a yes over here, and I see people over here vigorously shaking their heads no. How would we have such a disagreement?
Well, when he signed the original contract, he set the term like in 90 days for negotiate before the contract.
Before the contract expired.
And the provision of the contract, the first 45 days, he cannot initiate any negotiation without another company. So
with anyone else, and then during the last 45 days of the contract, they have the right to match any offer he gets. So is that about right?
Yes.
That was an oral agreement he made with CBS, so it wasn't.
Yeah, but that's a negotiation.
Okay, wait a minute. It's a CBS though, but that's his agreement with ABC, is what you're saying?
Yes.
So during the last 90 days of the contract, we will negotiate a new one. And the first 45 days, the first 45 of the last 90, I'll only negotiate with you.
That's the
Okay. So did he actually negotiate with CBS during the first 45 of those 90?
Yes. He
Joe's shaking his head saying no.
They are saying that when began the negotiations was October.
So it was before that 90-day period kicked in.
That's what I understand.
Yeah, no, but the 45, when is the contract end?
No, but wait a minute though. We got to get this down, because this is, I think, it's a crucial
I
piece.
pull up the timeline in this.
He says during the days 90 to 45 before it expires. Let's do it that way. During the days 90 to 45 before it expires, I can negotiate, and I agree to negotiate exclusively with ABC
Yeah.
for potential terms of renewal, right? And then during days, so that was 90 to 45, from 44 in, I can negotiate with others on a new contract, and I have to give you the right to match, right? Those are the terms. Joe's saying, I think he's saying, he didn't negotiate from 90 to 45, he negotiated from 120 to 110, say. And that's not what, the contract didn't say I couldn't do
It
that.
says after the termination of the
2
exclusive
months
period.
before it started negotiating.
Okay, but
On February 1st, 1980, after termination of that exclusive period, Wolf and CBS orally agreed to the terms.
The contract,
But it says, as we're saying now, that at some point, some of this originates before that 90-day period kicks in, doesn't it?
yeah, he met, the contract ended on March 5th in the 80, and he met with CBS. He had a conversation on October 15th. Is the period during the first 45?
The 90 days starts on December 6th.
You can sort of talk all you want,
Even
though. I mean,
worse.
there's nothing
No,
was
because
agreed.
it's not within the period, it's before.
Before.
It's a tricky thing. The contract says the 90-day period, doesn't say anything.
Before
Before the
the
expiration date.
before the expiration. So
Well, right, but just, I think the part we're looking for that we're a little bit at odds with here is, on my book, it's the top of 197. It says, Wolf first met with ABC executives in September 79. So well before this 90-day period. Might be 150 to 130, right? To discuss the terms. Counter proposals were exchanged. They went back and forth. And they agreed to finalize it by October 15th, but doesn't look like they did much. And then it says, meanwhile, unbeknownst to ABC, Wolf met with representatives of CBS in early October. So that's November, December, that's like 90 days, at least 60 days, say, just so we don't have to screw with the math. That's at least 60 days before there's any exclusivity
Kicks in.
provision in place. Right? Danny?
Yeah, there's a paragraph here. It says, if there's no basis in the record for the appellate division's conclusion that Wolf violated the first refusal provision by entering into an oral sportscasting contract with CBS on February 4th. The first refusal provision required Wolf for a period of 90 days after the termination of the ABC agreement either to refrain from accepting an offer of employment or to first submit the offer to ABC for its consideration. By its own terms, the right of first refusal did not apply to the offers accepted by Wolf prior to March 5th termination of the ABC employment contract. It is apparent, therefore, that Wolf could not have breached the right of first refusal by accepting an offer during the term of his employment with ABC. Rather, his conduct violates only the good faith negotiation clause of the contract.
So okay, but so what does that mean? Because that's why we need to get this down here. The way I'm reading it is that he's got a wink and a nod deal with CBS before that days 90 to 45 ever come into play. No?
I didn't read it as that.
Well, look at the paragraph, right? The parties agreed to finalize the matter by October 15th, but they don't. But they didn't know that he had met with CBS in early October.
But there was nothing agreed on that paragraph on February 1st, 1980. It was outside the exclusive period when they orally agreed on something. Yeah, they had met and they had discussed.
well, that's a negotiation.
But
So they negotiated in
That's a
October.
negotiation.
But even if they did, doesn't violate the terms of the agreement, because the agreement don't say only, I will give you exclusive negotiation rights for days 90 to 45. We didn't say anything about days 130 to 91. Right? So that's my first question for you. So, would you do this? Because it seems like you've gone out of your way to try and circumvent the intent of the parties. The language Danny read to us, it's, court said, talked about good faith and fair dealing. I mean, doesn't appear that they intended for you to be able to go out and negotiate and discuss with competitors a better deal for yourself before we get that first crack at the 45 days. Or, well, if that's what you intended, you should have written it that way. You didn't write it that way. You didn't say during the term of the whole contract, and especially the last 45 days, you won't negotiate with anyone. You didn't say that. You won't discuss contract terms with anyone else. But if you've already got a wink and a nod deal with CBS in early October, what the hell does that do for my exclusivity provisions from 90 to 45? You sort of made it a nullity, haven't you?
They intend to the parties to get a first refusal to ABC. That's the intent of the contract in first place.
So I need to know, would you do this? Wolf says, listen, I want out. I can make twice the money with CBS now that ABC has spent all this money on me, training me, teaching me, and in that business, even making you infinitely more valuable.
And he's saying it's your job to get me out.
And that's what, yeah, right, that's what I'm saying, get me out.
You know, he's saying...
Be my good lawyer.
Yeah.
So you would do that?
I think of the industry.
Huh? Oh, that's the industry, and you're just the weapon to help.
I think it's kind of...
So no one has any misgivings about this? You read the contract, you look it through and say, well, there's a loophole, you know, if we start early, we can go talk to CBS now. The way it reads is CBS only has an exclusive from days 90 to 45. We ought to get cracking and go talk to them now.
But ABC can still sue him, they just couldn't get this equitable relief, you know?
Well, let me ask you about the equitable relief, because that's obviously an important part of it. Assuming he violated the provisions of the agreement, could ABC get equitable relief and force him to continue, get an order from the court, to force him to continue to work for ABC and be their sportscaster on the regular sportscast each night?
No.
Why not?
Personal
I mean, what's the harm? It can be calculated as...
Well, the harm is that I've got someone worth an enormous amount of money now, and it really is not replaceable. I want him, and I want him saying that the sportscast every night. Can I get such an order?
No.
Why not?
Personal service.
So it's a personal services contract. You cannot get specific performance of it. Is that right?
Definitely not in this situation.
No, is that right? So Al agrees to paint my house. He says, screw it, I'm not painting your house. I say, no, Al, you're going to paint that friggin' house. And I'm going to go get an injunction. Can I force Al to paint the house? Can I get an injunction? Why not?
You can force, the court can force, I'll pay you the money.
But they can't force Al to paint the house.
Yeah, to somebody to paint the
You
house.
can't get, go ahead.
You can find somebody.
So I can get someone else to paint.
Somebody else just as good.
I can pay Al to paint the house. Maybe it'll cost me more, and Al will have to pay for that.
Yeah.
But Al doesn't have to. The court will not force Al to paint the house.
That's right.
You cannot get specific performance or injunctive relief as a general matter to force specific performance of the personal services contract. Why? Because it is a question of the involuntary servitude, but it's also a question of, okay, I'll tell you, so the court gives me an order, paint the house, Al. And he paints it like crap. He's, and now we're back in court again, saying, well, you asked him to paint it. He painted it. He's not a very talented painter, as it turns out, but he painted it, right? And so it's not just, we can't force Al to do something he doesn't want to do. It's also, when we do force him, now we've got other issues with respect to how do we gauge the performance of that contract, and do we really expect, frankly, as a practical matter, that Al's going to give it his best shot anyway when he's been forced to do something like that. And so historically, you can't get it. So if ABC can't get him back, can I keep him off the air at CBS? Because I don't care if, well, I would like him back, but I understand what you guys are telling me the law is. But I'll be damned if he's gonna go work down the street and take all the goodwill that I have paid for the last 5 years, and then immediately I'm losing ratings, I'm losing advertising revenue because he's screwed me over yet again. He's made a lot more money, but I've lost, not just lost a fortune, I've lost stuff I may not get back in the terms of viewers and the loyalty to the station and everything else. Could I potentially keep him off the air?
No.
Huh?
He didn't have a
No.
covenant not to compete.
Well, but he's breached the terms of the agreement with me, hasn't he? I mean,
How is it?
But it's a
This is after the
fundamental
contract.
right for him.
This is after the contract ended. Didn't it say if it was before?
well, okay, let me ask you about that. Let's not, we can get back to that. But if there is a breach of contract, shouldn't I have some ability to either prevent him from working for someone else, right? You don't have to work for me, but you don't get to work for anyone else. Al, you don't necessarily have to pay my house, but you're not paying anyone else's then either.
That's an
You don't have to work for me, Warner, but you're not working for CBS. Did you say why?
But
I said, no, it's not fair. I mean,
That's not fair to keep him from working for someone else?
no, it's not. And the court doesn't favor that.
But why not? Why shouldn't it? If he's under, well, let me ask you this. Let's say he's under contract with me. He's got another year to run. And he says, you know what? I'm not going to do it, Mike. I'm done. I'm going to CBS. Can I now prevent him from working for CBS?
Even an injunction.
Depends on if there's going to be harm, shouldn't it?
Well, what do you mean? I'm saying, listen, we have a contract that says you're supposed to work for me for another year. There's no doubt that's what it says. You could just say, screw it, I'm going to go work for CBS, I'll pay damages. Why can't ABC go in and get, okay, I can't make you work for me for another year, but you're not working for CBS for another. You're not working for a competitor costing me millions and millions.
in the second,
That's one form of injunction. He said
So I could get that or I could? Listen, I could not?
that he could
no,
not.
in the second scenario, you can allow the court because the first scenario, you cannot tell you're not going to work for nobody else because the individual have the right to earn the living. This is a fundamental right.
Oh, wait a minute. When you talk about what happened to covenants not to compete, we enforce them all the time.
Yeah, but how are we going to earn the living?
You're not in this business. That's what you agreed to. Right? That's the whole idea about the covenants not to compete. You won't take bread out of my children's mouths. Not when I've trained you, not when I've taught you the business, not when I've paid you for those things and paid you when you signed that covenant not to compete, you agreed to do this. Isn't that?
He didn't have one of those.
No, he didn't have those, but I'm changing the facts slightly and saying he didn't have those. But he has agreed to work for me for another year. And he's saying, you know what, screw you, Mike. I'm going to go work for CBS. They're going to pay me 3 times the money, and they're not going to yell at me like you. So he goes down the street. Doesn't ABC have the ability now to go into court? Okay, you don't want to work for me. I understand your argument. I can't get specific performance of a personal services contract. But don't I have the right to make sure he doesn't do those services for anyone else because he's under contract with me?
Well, what's the irreparable harm?
To me, I'm going to lose ratings, I'm going to lose revenue, I'm going to lose goodwill to the station. Especially in this business, less so now than it used to be, but people do follow these folks.
I think that would be
Right.
enforceable.
But in the second case,
No, it's not a covenant not to compete, it's just a straight contract. I'm saying you breach the contract, you don't want to work for me, fine, but you're not working for anyone else until this contract terminates.
but the person in that particular case
Has a contract.
in the particular
Okay.
contract have the alternative. Have the
Yeah, he could stay working for me. Okay, I'm with you, so go ahead.
How about liquidated damages in the contract?
Well, oftentimes that's going to be my choice whether I want liquidated damages. The problem with these is they don't necessarily, you guys, we've seen it a little bit around here lately with NEC and NBC Boston and Channel 7. They're within all their contracts, they're usually going to be off air for a while. Why? Because we want some of that to dissipate, the goodwill, the loyalty to the personality. Not uncommon at all, and this, you know, this type of action is, okay, you want to go somewhere, you're going to have to be gone for a period where you don't just get to reappear. I mean, look at the ads a lot of these stations spend on promoting their personalities. This is especially, you know, Boston, New York, they're all very competitive media markets. Why shouldn't they have the right to prevent him, who's under contract to me, I'm not saying this case, but under contract to me, for making sure that either I get the benefits of my contract, or no one else gets to benefit while he's under the terms of that contract with me.
I thank you.
But, so you, in one of the examples that you gave, so you said, oh, well, Mike, I'm going to go work for so-and-so because they're not going, you know, they don't yell at me, stuff like that. I mean,
I gave you that as a little icing on the cake.
But I mean, hostile work environment, your business relationships broken down. You know, you
So, but is that all you have to do is just sort of throw out that he's a bastard, now I can breach a year's worth less on the contract, go make twice as much money somewhere else? Remember, I mean, that's the way you understand litigation. People don't just say, you're right, but I'm leaving anyway. No, right? That's the problem with it, is that there's all of these arguments, but at the end of the day, listen, at the end of the day, Warner Wolf's leaving because he's getting a lot more money, right? And he knows it, and at this point in time, he's hot, and, you know, you strike while the iron's hot. But okay, first of all, let me just say, I think you can for that period. But that's not this problem. Go ahead, David.
The court actually said an injunction is warranted because the employee either expressly or by clear, well, actually, let me just say, it's basically, it sounds like if you agree not to work elsewhere during the term of the contract, it follows the same rules as the covenant not to compete,
Right.
except before the contract terminates.
Yeah, if it goes that route. Okay, but now, and that's right. Now let me ask you about the parts of it here that we sort of moved past a little too quickly. So your client says, I want out. Would you do this, or is this dishonest? Or you found a loophole? I'm just wondering. That's your job?
You probably negotiate first before you do the loophole thing. I don't think it would be a better course of action.
Well, but I think.
Negotiate with to get out of the contract.
But then I tipped a little bit too much of my hand there.
Well, tell them the loophole.
Well, but isn't that what I see? I think in part what they did here is when they met in September. Now that's well before that 90-day provision kicks in. It looks to me like they thought, we're not going to be able to get a deal done on as beneficial terms as I can get down the street, right? It says counter proposals were exchanged. And then they agreed to finalize it by October 15th, which means that it would appear at some point there was some urgency to it. Then all of a sudden nothing happens until February 1. I mean, that seems kind of odd that they didn't know that this was turning bad. And I guess I get some understanding of what I think I'm worth or what you're going to pay me in September. So why not see what's better down the street? So the agreement says that, well, let me ask this. The agreement doesn't prevent him from going to talk to CBS in October, does it? Not by its language. So does that bother any of you that, or you say, well, okay, it doesn't say it specifically, but the intent at least would appear to be that you don't negotiate with anyone other than ABC until there's only 45 days left on the contract.
I think that infers way too much good faith on both these players. Gone are the days of that kind of loyalty being extended by his employers to him. He's aware of that. They're aware of that. They wouldn't extend anything more to him than that was what in the agreement. I don't think he owes them anything more than was in that agreement.
So do you think it was the intent of the party? Do you think it was the intent of the parties that the only time there would be an exclusive period would be days 90 to 45 left of the contract?
Yeah.
I think
That's what you all think, or you
They
just say, you
They only
say?
get to decide it if it was within the limited boundaries that he would be willing to go along with, right? I mean, this is not an unpredictable outcome.
That, well, wait a minute though, if you're supposed to, let me plumb this, because I know we can sit here and say, oh no, how could they not? Aren't you rendering my exclusivity period of days 90 to 45 absolutely meaningless if you've already got a wink and a nod deal with someone preceding that time period? What good is it to me to negotiate exclusively with me on days 90 to 45 if you've already got some type of handshake deal with someone else? We can talk, but you're rendering that chat meaningless, aren't you?
But you're also looking out for your best interest, because at the end of the day, because there was, the way I'm looking at this is, because there was that gap where no discussion or agreement was made and there was kind of a limbo, if you will. I mean, I'm looking at this as maybe they wanted him to just quit because they wanted to or get a better deal and say once he quits, oh, well, okay, we'll sweeten the pot up.
I don't think they wanted him to quit. This was probably as big as he was ever going to be in this period of time. I think they thought they could maybe get him on a lower figure than he wanted. And so maybe they could lowball him and bring him in. I mean, but I want to go back. Haven't you rendered that negotiation period from day 90 to 45 meaningless? Because what was the value of giving it to me if you already have struck a sweetheart arrangement with someone else? No? Or go ahead.
But isn't this going to be a common scenario in practice where a client comes to you and says, I signed
Yes.
this contract, I think I can
What's
make
my out?
more money elsewhere. Yeah, get me out.
Yeah, it is.
So
But
are you
that's
going
what.
to say it's not in good faith, I'm not doing it?
Well, is it? I don't know. That's what I'm asking you. I'm asking you because I think it is common. Sometimes some people come to us, or sometimes we're able to force them to do this. Here's the agreement. Well, it doesn't quite say what you think it says. No, I need him to do it. I need them to move off this. And because that's a possibility here too. CBS thinks he's tied up, and there's going to be a lot of litigation. They say, "Oh, screw it, we can't go with this uncertainty." But so is that part of your role here? You're just like you're the troublemaker?
No, you're advocating for your client that comes to you and wants out.
And are you worried at all that by advocating for your client under these circumstances, you're being a little sleazy?
A little sleazy.
Huh? Just a little? No, but that's okay. Or you don't see. Okay. Or the alternative is, Professor, and this is what you're saying, there's nothing dishonest about it whatsoever. If ABC wanted to pay for an exclusive period for the duration of the contract, they certainly had the money to do so, and they had lawyers, right? This isn't the mom and pop shop here. ABC's got plenty of lawyers. If that's what they intended, they should have written it exactly as they intended, and not having done so,
Yeah.
That's the way I feel.
that's I'm free to do what the contract allows me to do.
They can only place so many restrictions on somebody that they're going to employ.
Agreed, but these are likely this deal is absolutely a golden handcuffs. I mean, no one should think about this poor guy as an indentured servant. He's likely riding in the limos to and from work, and he's making big bank, so you only wish that you had such a horrible working conditions as Warren Wolf likely had at this point in time.
2 hours a day.
Yeah. Yeah, the old days, that's all it would have been. Now they work them to the bone.
But I mean, you say to the client, it's not in good faith to negotiate, to look at the contract and see what it says, so we're giving up.
But is it, or is that, because I'm hearing, well, what's not in good faith here? What's not? I'm looking at the language of the agreement, and the only period where we can't talk to anyone else, and it's clearly stated, right? I think we all agree, the only period where it's clearly stated, I can't talk to anyone else, are days 90 to 45. We're not there, and by this account, it doesn't appear he does that, right? I don't think anyone says, nope, he doesn't, he really doesn't do that, talk from 90 to 45. He doesn't even after, and by the way, let's go a little further to see the level of cunning that you employ here. So then after the exclusivity period terminates, you then have him sign a production agreement on February 4th. And that means he's going to be a producer, not non-air talent, which means there's no violation of the agreement then. So he's going to be a producer. And then you also created an option on for $100 to hold open and offer employment until June 4th, the date in which Wolf became free of ABC's right of first refusal. So, I mean, you structured it to make sure that you timed it so that there was no technical violation of that 90-day window.
But it's
But so let me get my question out. Yeah, Professor, what's your point? That's what lawyers do. No, is that right? I mean, if you're going to do it, you got to do it right. And it does appear, but that's my question to you. Yeah, that's what we do.
You take an aggressive stand, and
Client wants out. There's nothing here, at least strictly by the letter of the agreement, that is improper, and he gets to go to his new job. So that's nothing improper, nothing wrong. That's precisely what we are engaged for our services, is to figure out exactly how we can try and address what the client's needs are. I mean,
but it's either a yes or no question, right?
But
is it? I don't know.
my question is, it's not good faith. He's negotiated with good faith with ABC, like you mentioned.
Did he?
No, what is the purpose of negotiation if you already have a deal?
Well, but that's my point, is there is not going to be any really good faith negotiation with ABC, is
There
it?
is no.
And that's where I think the language Danny first quoted us is where it becomes problematic for it. How can you give them what they bargained for when, by all accounts here, it looks like you made arrangements with their competitor? But is that so? But this is precisely what lawyers are supposed to do.
Yes.
It is. And do you not, I mean, here it's only money, but you don't, there's nothing, you don't feel that there's anything improper by your actions in circumventing the contract? Or do you not see it as circumventing the contract? Because I think you're circumventing it, but if it's...
But isn't it the minute that you say you negotiated in bad faith?
Circumventing in a permissible way.
Yeah, I think it's,
Well, I do. That's why I hesitated to add it, because that is what follows, I think. And I do worry that doesn't sound quite right. But
it's better lawyer.
so that's what it is.
Yeah.
Because ABC has plenty of lawyers. And if they wanted something else, and I'll bet they did something else after this fiasco.
So if you don't do what they did, then you automatically lose.
No, you just might have more uncertainty until you're actually free of the contract. Here, he was boxing his bets. I mean, because his leverage is right now. They want to hire me from a competitor. They want me to bring that to them. If I wait until I thumb my nose at ABC, then ABC may say, well, you're never welcome back. And now I've got less leverage with CBS, and they won't pay me or give me the same terms that they will right now. I've got the most juice I'm ever going to have right now, and I intend to leverage it. And he needs you to help him leverage it. And I guess I'm hearing the answer is, sign me up, boss. No, right? And that's okay. So that's what we do. And especially, it's only money, so no one feels bad. It's ABC and CBS, so there's no,
Yeah.
who cares? Huh?
They're gonna get a better contract next time.
And ABC will fix the flaws in their contract for next time. So we'll all do this. We all won't feel bad. It's only money, big companies, who cares?
Can't we say that the franchise agreements that the lawyers sit down and draft, and they know that it's going to be for their side and not for the other side, similar to the situation? We're doing this with the intent of hurting the other side. Because we know that they're all one
Well,
side.
hurting the other side or advantaging our side to the extent we can. And by the way, Dale's first point about this is right? If I get first crack at the contract, I'm going to put stuff in there that you shouldn't agree to. And if you do, that's not on me. No, is it? I mean, right? My job is to try and grab as much leverage as possible for my client. And, so your lawyer will pick up a couple things and you'll think, he did a great job, he saved me from this or that. That's okay, but you missed another 3. So, but is that what I do? So I'm supposed to load it up and then maybe we'll get something, we might get some balance. So, but that's okay. That's what we do. Our job is to protect our client to the extent we can. So you all see it that the lawyers for ABC screwed up in writing the contract.
Absolutely.
Yes.
So how will you avoid then screwing up in the same way? Because I really don't think until this was done this way that they really anticipated that someone would attempt to circumvent. And even the court says, by the way, that he's violated the covenant of good faith and fair dealing here, hasn't he? That we all know what the day 90 to 45 is supposed to represent. And it's not going to represent it the way this worked out. So he's going to pay. He's not as clever as he thinks, but there won't be an injunction. So
He's going to come out way ahead.
So it's all ABC's fault, their lawyer's fault. So how do you make sure that you don't do that? So now we got to go the full belt, suspenders, and God knows what else approach every time we write it. We overwrite every agreement so that no wonder all these people curse at you lawyers.
Bulletproof contract?
If there is such a thing. But that's what we've got to try and do. Because even here, with the competent lawyers they had, someone else looked for ways to try and circumvent what the intent of the parties likely was. I mean, we got to recognize it. And by the way, if this was a private lawyer, then ABC's coming to say, you didn't give us what we wanted here. This cost us hundreds of thousands, if not millions of dollars. Help us out here. And they're not really saying help. They're saying it's a demand, right? But, this was a couple of years, Frank McCourt's agreement was written, which was written by, what the hell's the name of the firm? Large firm in Boston. Frank McCourt was the owner of the Dodgers, and he had a lot of property on the waterfront. And the language in the agreement, trying to separate out really $1 billion in assets, the language was faulty. And they ended up suing the firm for hundreds of millions of dollars, saying that agreement doesn't say what we had intended it to say. So the mistakes can get bigger, and they're still going to come back then on you. And that's what likely here. ABC's lawyers, as you guys all said already, are likely going to write a better contract next time, but that doesn't mean that they're not on the hook for some of this problem this time. So you're going to write bulletproof contracts, or at least you hope you are. Couple things to think about in this case as you look at it. Courts of equity, as it says in Roman numeral 3a, have refused to order an individual to perform a contract for personal services. And, you know, it says, originally this rule evolved because of the inherent difficulties courts would encounter in supervising the performance of uniquely personal efforts. And then it goes on to say in that next paragraph, thus when an employee refuses to render services to an employer in violation of the existing contract, and the services are unique or extraordinary, an injunction may issue to prevent the employer from furnishing those services to another person for the duration of the contract. That's that negative enforcement that we were talking about. Okay, you don't want to work for me, you don't have to, but you're not working for anyone else during the period in which that contract is supposed to be in force. And that's what we can get. But then it goes on at the top of page 1099 to talk about that there may be terms where you can get specific performance of that contract if it's necessary to protect trade secrets, customer lists, goodwill, special harm. Because of the unique nature of the employee's services, I might be able to get some type of specific performance, although we want competition generally. Here, you know, we're looking at damages that are likely flowed from the breach of covenant of good faith and fair dealing, negotiation. But they're not going to get equitable relief. Doesn't mean, though, that they can't and won't pursue money damages, but that's what they're going to be limited here to because of the manner in which it was done. You know, the dissent goes on. The dissent talks about something similar to that, such unique goods and the like, that maybe this should get some form of negative enforcement and the like. You know, the dissent talks about the difference in numbers here. And this was 20, 30, nearly 40 years ago. Those are pretty good-sized numbers if you think about those numbers from 40 years ago, that the difference between what ABC was paying him and what CBS was going to pay him in just a few months once it went forward. So that's where we start as we start to think about the specific performance of personal services contracts. We have the next case is Vanessa Redgrave versus the Boston Symphony Orchestra. And because of her outspokenness, the BSO doesn't want her to play anymore because there are a number of patrons of the Boston Symphony Orchestra who feel that her causes, her words, are hurtful to them, and the BSO cancels her performance, gives her her money, and says, see you later. She sues in federal court here in Massachusetts under both state and federal law for specific performance of the contract. She says, I want to play with the BSO. That was what the agreement provided. That's what I'm prepared to do. It's an important event. It's important to get to my career, reputation, to be able to play for the BSO. And therefore, I want the right to specifically perform the contract, just like that contract said. So if you look at the decision, she sued for a whole bunch of different reasons, which is not uncommon, as we've talked about in federal court. You combine both your federal claims and your state law claims. State law claims fall in under supplemental jurisdiction. So she's got, if you look at Roman numeral 1, a whole bunch of different statutory and common law reasons for suing. BSO moves to dismiss all her claims under Rule 12, saying she's failed to state the cause of action upon which relief can be granted under the law. And she, meanwhile, is seeking specific performance of the contract she wants to play. And the BSO says it's a breach of contract claim, She gets her money, that's all she'd be entitled to get. You can't give specific performance of this personal services contract. What does the court ultimately do with it? Can she get, okay, we know the employer isn't likely to be able to get specific performance of the personal services contract. Specific performance is usually reserved to really unique goods, maybe extraordinarily unique talents somehow. But can the other side somehow demand specific performance? Or is this just then if your boss says you don't work here anymore even though you got 2 years left on your contract, I might have to pay you the 2 years in benefits, whatever I agreed to, but I don't have to keep you in my office. You're out. It's a contract claim. You don't get to go to court, get an injunction, and say, I still work here. What's the deal? Does she get to perform as her contract required, or is the BSO within their rights to say, nope, you're out, here's your check, goodbye. Damages is what you get.
Well, the court said that there was a breach of contract.
Say what?
The court said there was a breach of contract by
Yeah,
BSO.
Well, there was, right? She was supposed to play. Now, because of her outspokenness, which, I mean, obviously she has a First Amendment right to speak, but BSO has a lot of sponsors and they have a right to voice with their pocketbooks too, and they're saying there won't be any more money coming to the BSO if she performs. So they cancel her because it's in their financial interest. No problem.
Well, she cannot prove because BSO concede they owe the money, they pay the 31,000.
It's a breach of contract. The remedy for a breach of contract is money.
Is money.
Here's your money.
So they said they're going to pay.
See you later.
Yeah,
No specific performance, even though I imagine it must be quite prestigious to play for the BSO. Have any of you ever played for the BSO? It'd be kind of cool, though, huh? Probably be something reputational that's worth a lot, too. Doesn't matter.
but she can prove that she cannot play in another place because she only gave additional damage. So she cannot prove that she wasn't hired because that.
Yeah, they said it straight out because their views on Israel.
Oh, yeah. I don't think there's any doubt that's why. You have the right to talk. But free speech, as you all know, isn't really free.
Oh, good.
Right? So they have the right to do what they want to do. And she has the right to talk, and she has the right to be compensated for the breach of contract, but that's it at the end of the day, right? And she doesn't have an intentional infliction of emotional distress claim, top of page 236, that the actor intended to inflict emotional distress or knew or should have known that emotional distress was likely the result of his conduct, doesn't look likely, that the conduct was extreme and outrageous, not so sure you're going to hit that, beyond all possible bounds of decency, utterly intolerable in a civilized community. Is it? You talk a lot, you run your mouth. Most of us don't get $31,000 and not have to work for it. You know, they're within their rights. She's not getting specific performance. You can't and aren't likely on most contracts to be able to get the court to think that those contracts, those items are of such uniqueness that you're likely going to be able to get specific performance.
Good question.
Go ahead.
Assuming she proved because the cancellation of BSO
Was
she can get another contract in another places that she can prove that that's there's no additional damage for that.
I don't see that she gets consequential damages on this. It's my damages are what I agreed to pay you. Here's your money. They don't, I think they only leave one claim of all of her claims outstanding, right?
Isn't she trying to say that it ruins her reputation?
But yes,
she
I think she's trying to claim that, but this is who she was. She was highly outspoken, probably known as much for her dramatic talents as her outspokenness. Sort of comes with the territory. You have to accept that there will be some that will like you for it and some that will despise you for it, and it's really not the BSO's fault. The BSO is protecting its own economic interest here. But I think they left one count of her multi-count complaint outstanding. I'm trying to remember which one. All the others, I believe, were dismissed.
1 and 6, I think they left over.
That's all that's left?
They dismissed 2, 3, 4, and 7.
So,
1 6, 1
which ones were left?
Breach of contract.
Well, breach of contract, right? I mean, there is a breach of contract.
She did a one on,
And a right to her views, her political views.
Yeah, but what one does she have left? Other than the breach of contract?
that the boss, that the orchestra had violated her civil rights by firing him.
Yeah, she can argue that she has that claim left. Whether it's likely whether she's going to win anything on it is still a hard sell as well. Because if you look at the language, look at the language of the mass civil rights. They have to show that they interfered with Red Graves' rights by means of threats, intimidation, or coercion. I mean, that's going to be tough to be able to establish that. And again, look at the language here in the last page of the decision, 243. And that plaintiffs should not be allowed to bootstrap a breach of contract claim. And that, at the end of the day, that's really all it is, into a civil rights action. That she's alleged, though, as the last paragraph goes on to say, deprivations of constitutionally protected speech. And that's true. Whether they're going to be able to show that it was done through threats, intimidation, or coercion is, I think, unlikely. I think the court feels it's unlikely. But that's not what a motion to dismiss should be granted on. A motion to dismiss says that the plaintiff can prove no set of facts which would entitle them to relief. It clearly are civil rights implications to it, but whether she's going to be able to show threats, intimidation, or coercion sounds highly unlikely.
Is this the case where they were stating that that she didn't prove there was any state action, or is that a different case?
I don't think this one talks about state action again.
I remember one of these cases saying something about that. For sure.
We have one more of these specific performance cases in the sequence, and that's this Florida Panthers versus Miami Sports Authority case. And this one, they do allow specific performance of what they call a personal services contract. And that's why I've got it in here, because I think it's unusual. But if you look at it, it's a lease, and it's it's for a hockey rink, obviously, and there are limited facilities where a professional a hockey team could play play in an arena with their fans there. But that one starts with where we're starting to look at specific performance of a personal services contract. I wanted you to start to think about, we'll open the door to it, and we've got actually a few minutes. Johnson versus Calvert gets us into the whole argument, discussion about surrogacy contracts and where the specific performance and the like falls into this grouping of cases. Johnson versus Calvert deals with the contract to provide surrogacy, or to make arrangements for a surrogacy arrangement, and what the terms of that contract require and how that should work. If you think about these surrogacy contracts, as you start to think about them here, look at this one alone. So Mark and Crispina Calvert are the married couple who wanted to have a child. She could produce the eggs, And so what they needed was a true surrogate just for, in essence, and one of the articles talks about it. And you really ought to look at the articles in these cases because they're very interesting and there's all sorts of issues raised by this stuff. And you might say today, oh, you'll never be involved in one of these, but you likely will, and of some fashion. A lot of times after we finish this week, someone usually emails me and says, you know, that's how we had to have our baby, and that's, you know, we wouldn't have had it otherwise. So there's all this is a lot more extensive, and the law has struggled. I think we're much better than we were, but struggled to catch up with the technology involved. But so here we've got 3 potential parents to this child. Mark Crispina and the surrogate, who really is the womb for rent, Anna. Because Mark was going to provide the sperm, the egg was Crispina's, implanted in Anna, and the child would be taken into Mark and Crispina's home as their child. A lot of times there's even more players than this, and you start to think about all the various parties that potentially are involved in the contract. Sometimes there's both a sperm donor and an egg donor, in addition to the putative parents, or what you should look at as the procreative parents. And the cases talk about the procreative parents as being who gave birth to the birth of the idea about having a baby, right? Who were the parties that came together and said, let's have a baby? But so that's where this all starts with. Oftentimes then, though, there would be a separate, many times, there's a sperm donor, there's an egg donor, so now we have 4 people, right? There is a surrogate, so now who that egg and the sperm will be implanted into, now there's a 5th person. There is the surrogate's partner, so now we have potentially a 6th person, all involved, all potentially having something, and some potential legal rights with this transaction. And so, and unfortunately, sometimes they go real bad. And if you're thinking about writing that old bulletproof contract for Warner Wolf, you better damn well do a really bulletproof one for this, because there's going to be no storm like the storm that's going to surround this if this deal goes bad. So there's all sorts of things that I want you to think about, and I'm going to ask you before you go to start to think about them, and we'll talk a little more about them, a lot more about them next time. But the agreement had, Anna's going to relinquish all rights. They'll pay her $10,000 in a series of installments, the last to be paid 6 weeks after the child's birth. And they're also going to take a life insurance policy of $200,000 on her. She becomes pregnant. Relations deteriorated between the sides. You read the stuff. Anna felt that she was abandoned. She wanted her money, or she's going to refuse to give up the child. They filed a lawsuit. Think this is what a happy day for. They're going to have at the birth of this child now. There's competing lawsuits, and the rights are very limited. So they sought a declaratory judgment saying they're the legal parents of the unborn child. She files her own action to declare the mother of the child, who that child is going to leave her womb. And ultimately the cases were consolidated. They then had to appoint an independent guardian for the purposes of the child. And in many ways, lucky for them, at least biologically, blood samples confirmed that the egg donor is the person who provided the egg for the birth of this child, and the Mark is the person who provided the sperm, and therefore the science supports that she's the genetic mother and he's the genetic father. and then we go with visits and all the rest. So now the question is, who's the mom, who's the dad? Well, we don't, not for this case, who's the mom? And which one of them is the mom? Is it the one that carried her to term, carried her for 9 months, felt the baby move on the first time and the last time before the child was born, or the people who just provided the goods to make this project a go? So I guess, like in part, who does your car belong to? Does it belong to you? Or all the component makers? At least that's the way Anna would see it. And this becomes problematic if you think about it, because, you know, one thing, at least I think early on, people said, well, why go with the extra step of the egg donation? Well, if the surrogate provides the egg as well, now we've got another bigger hurdle potentially to overcome. So, I mean, you have to think about both the science, the law, and the practical aspects here that are all attendant in large supply. And so there's some arguments about the surrogacy contracts. Involuntary servitude, you guys were telling me, oh no, we can't do that. Really? But I can hold your body captive for 9 months and have you do what I need you to do, and then at the end of that period just expect that you're going to sign over those documents and say, see you later? I mean, this seems like contracts fraught with not just legal issues. Well, first of all, can I ask, does anyone think all of this should just be prohibited? You can't sell your eggs, you can't sell your sperm, you can't sell your body for 9 months to house as an incubator.
Yeah.
You wouldn't what?
It shouldn't be prohibited.
It should not be prohibited.
Right, to be
So you can sell those various body parts for as much as you can get.
Well, they don't really have control over her body for 9 months. If she gets to that point, then they get the baby, but it's still her right to abort it and stuff like that.
Whoa, we haven't got there yet. I'm just, because I'm going to ask you, if I'm paying a lot of money, if I'm paying a lot of money, I am going to control it for 9 months.
But
Aren't I? Because I'm going to ask you about that. That's what I'm going to leave you with, that I want you to start to think about. If I'm paying, and by the way, this is my child, right? So I'm expecting
Shared interest, right?
Huh?
It's a shared interest, not just your child.
No, it is.
Partially.
It's my partner and my child. You're just the womb. No, that's what they are going for rent. You decided to rent out your body like Airbnb. That's not on me, is it? This is the argument, okay? And I am going over the top because I would like to know. But by the way, first of all, before I get to there, so you can sell your eggs for as much as you might like. 5,000, 10,000, 50,000. Law students, maybe you guys go to the top, maybe north of 50,000. None of that bothers you either?
Depends on you.
Because there's ads, you can either Google them, or there were some on the boards I pulled down for the purposes of the class, not for anything else. Pull down that say, they're looking for a college-educated, intelligent person that's 5.5 feet or taller, Scandinavian descent or whatever. Sometimes they'll say, they want a baby that looks like them, right? That's so all of this, and so no one is a little troubled by sort of creating a little master race here. Go ahead.
I am. It's not a legal argument, but I don't support it more.
It's not. It doesn't have to be a legal argument. I mean, because there's problems with, as you think about and it's not just a legal issue here. It's a moral. For some, it's going to be a religious issue. For some, it's. I'll go there. Are you exploiting people who don't have money so that they can bear children for those who, let's say, don't want to have their body disfigured through childbirth? And there are some that it is not a medical issue, it's Okay, so these are the questions I'm gonna leave you with, though. I need you to think, okay? Because you're gonna write the terms of the contract. I want you to really think about the problems in this case, and I want you to think about the problems as to what terms I can put in there. I don't want you to smoke. I don't want you to drink. I want you to take vitamins. I want you to take regular medical care. What about sexual relations with your partner? Can I prohibit you from that? What about genetic testing? And then we're going to have genetic testing. I want to decide when I see the results of that testing whether I want you to go forward or not.
But again, it's a contract. If you don't agree with that, you don't sign.
Well, but so I can put whatever terms in there I want, and I can require you to undertake medical procedures that you wouldn't otherwise voluntarily do. Does any of you have a problem with me saying you can't smoke?
I have a problem with that.
Smoke? Smoke like that's like, no really, right? Like that's, I mean, people did it for ages, but see, I can't stop you from, Dickie, you won't even let me stop you from drinking or smoking during the next 9 months? And I hear you because, listen, the reason I started there is I intend to ask about a lot more than that. And so I need to know what provisions you're going to put in there. And I need you to think about what provisions would you allow the court to enforce then. Because what if Allie doesn't? What if she is smoking and drinking? Maybe doing a little crack. No, can I get the court to issue some types of orders? She's 6 months along now. That's my kid, isn't it? It's not just her body anymore. There's someone inside that I would like to protect. How are we going to do this? Can I make her or whoever give up their right to abort that child? Can I force them to do that? Because the child, I don't like the genetic testing here at all. And I don't want to raise a child that has significant disabilities. Maybe beyond my ability, maybe just beyond my interest. Does that matter? Does it matter, by the way, whether the surrogate is a family member or just just some poor kid who needs another 50 grand? I need you to think about this because I want to explore it a little further. With that said, I want to say one other thing. I told you that anytime we've had this discussion, there's been all various pieces. I didn't know at the time, but once, and she's published it, I'll find the article for you because this is what she does now, a graduate. She sold her eggs to pay for law school. She said that. I mean, she's published an article about it, that this was her gift to people who couldn't, as she saw it. But that's how she helped pay for law school. So this is not crazy, and it doesn't just happen to someone else. I know someone who's very close to me, she had, a surrogate had multiple children on her behalf. So, we'll talk.